Your employer can discipline and indeed dismiss you for things you post on social media. I'm Daniel Barnett, a barrister practicing in central London and the presenter of the LBC Legal Hour. This is your guide to what your employer can do if it thinks you've posted inappropriate comments or pictures. Quick warning, this video includes extreme language. I apologise for any upset this might cause, but it's included because I'm telling you about tweets that people have been dismissed for. If you think you might be offended, please turn this video off now. Any employer has discretion to decide whether something you post might amount to harassment of co-workers or customers, or damage their reputation, or damage their brand. Many of us are working more from home now, and so it might be hard for you to remember that when you post stuff on social media, your thoughts are published. They're not private anymore. The simple, stale truth is that most employees are ambassadors for their employer, especially if your employer is identifiable from your social media profiles, such as your biography on LinkedIn or via a quick internet search. Your employer has a vested interest in what you say and what you do online, and is therefore entitled in many circumstances to discipline or even dismiss you for inappropriate social media use. Even they can dismiss you for that tweet which you probably didn't give a second thought to at the time, or you might not even remember tweeting when you were a little bit drunk or just a little bit not thinking through the consequences. A classic example from the Employment Appeal Tribunal is the case of Game Retail against Laws. Mr. Laws was a risk and loss prevention officer for Game, a video game company. His job involved visiting about 100 stores in the north of England. He had a personal Twitter account, which was followed by various game stores up and down the country. His job involved travelling around the country, and he would tweet derogatory things about various towns and their residents. These are examples of some of the tweets. There were many others, very swearing content and attacking the police, attacking his dentist of all people, attacking A&E workers, and slightly bizarrely, attacking golfers. He was dismissed, and he argued the dismissal was unfair because his tweets were private. The Employment Appeal Tribunal said the tweets were far from private. Mr. Laws' tweets could be seen by the game stores that followed his feed, and it was irrelevant that he hadn't been tweeting about anything work-related. It was also irrelevant, said the Employment Appeal Tribunal, whether anyone was actually offended by the tweets. What mattered was that the tweets were visible to the world, they were visible to co-employees, and Game Retail thought they might cause offence, and that view was reasonable. What about Mr. Law's free speech rights? Article 10 of the European Convention on Human Rights protects an individual's freedom of expression, and that right is enshrined in UK law via the Human Rights Act 1998, which binds public authorities, and that includes employment tribunals, to have regard for an employee's convention rights, even where they work for a private sector employer. The tribunal in the Game case acknowledged that Mr. Law's Article 10 rights had been engaged, so there might have been a breach of his right to freedom of expression, but freedom of expression is not an absolute right, and it may be legitimately restricted in certain circumstances. In the case of Game, we see that in the employment context. Article 10 rights have to be weighed up in a balancing exercise between the employee's rights and the employer's right to avoid reputational risk. Put bluntly, an employee's social media use can be limited by an employer, and an employee can be fairly dismissed for objectionable posts, even where the employee concerned wasn't technically on duty at the time. So no one is entitled to insult or offend others without at least potentially facing consequences at work. And you might say that's as it should be. But you might also say that Mr. Law's crass tweets are in a different class from a profoundly and sincerely held religious belief or philosophical belief or political belief. Surely an employer can't prevent an employee expressing a perfectly lawful religious or similar belief online. The European Convention on Human Rights makes clear that you can hold any belief you like, you can hold it in your heart, but it doesn't mean you can manifest that belief in any context. And just because you hold a belief sincerely, when you manifest or express that belief online, doesn't mean that someone else can't take offence at your belief. Beliefs are protected under the Equality Act 2010, and the basic test for whether a belief is eligible for protection is whether it's worthy of respect in a democratic society. I'm oversimplifying here. That covers a very wide range of beliefs, from a belief in ethical veganism, that's a case called Casamitjana and the League Against Cruel Sports, to a belief that sex is immutable and should not be conflated with gender. That's the very well-known case of Forstater against CGD Europe. But just because a belief is protected under equality law doesn't mean your employer isn't sometimes entitled to take issue with it. In the case of Gibbons against the British Council, a British Council employee, Miss Gibbons, was summarily dismissed from the British Council for gross misconduct because she'd contributed to a thread on a Facebook page belonging to a band called the Dub Pistols. Members of the Dub Pistols had made derogatory comments about one of the children of the royal family, Prince George, mocking his appearance. Miss Gibbons added her thought that Prince George had white privilege, and this went viral, and it was taken up by the mainstream news media, including The Sun and the Metro. The press mistakenly attributed the attack on Prince George's physical appearance to Miss Gibbons, criticising her for attacking a child. She was dismissed. And at her employment tribunal, Miss Gibbons claimed discrimination on the grounds of belief. She was an anti-monarchist, she said. That's my belief. I don't believe that Britain should be ruled by a hereditary monarch. The tribunal accepted that Miss Gibbons' belief was a philosophical belief under the Equality Act 2010, but found there'd been no discrimination against her because the British Council, her employer, had a provision and a condition of employment that employees weren't to express political views in a public forum where the person holding those views could be associated with the British Council. In its assessment of whether the British Council was right to have such a provision, the tribunal found that protection of its reputation was a legitimate purpose and that the British Council had adopted a sensible means of achieving that purpose. The case of Gibbons shows that you might be held liable for statements you haven't even made. Miss Gibbons hadn't made the statement about Prince George, she'd merely commented on somebody else's, and the press mistakenly thought it was her. But this shows you can be held liable for statements you haven't even made if they can be linked to you, and if your employer is embarrassed by them. It seems obvious to say that when posting on social media, you have to think about the possible effect down the line caused by something you post. But it's not actually obvious to most people that they might be held accountable or even dismissed for something they didn't say but merely shared or liked or tacitly approved. Add to this the fact that you might not think something is such a big deal at the time you posted it. Indeed, you might have been under the influence of alcohol, but that doesn't mean it won't blow up in your face as a source of embarrassment to your employer, especially where you may have used obscene or vulgar language and therefore do come across badly as an ambassador of your employer. The problem for those of us who use social media, and if you don't follow me on Twitter, by the way, why not? Please do. It's at Daniel_Barnett, at Daniel_Barnett, is that we use it for leisure and for socialising as well as for work. This means we're more likely to post using informal language in comparison with how we'd address a person in the actual workplace. The takeaway point is that employees should exercise extreme caution and a sense of responsibility when using social media in any context. There's a certain sadness about this situation because English law has traditionally upheld the rights of individuals to express themselves freely, even where it might seem perfectly obvious to others that what they're saying is just wrong, bad, dangerous, or just plain bonkers. Social media is a cesspit sometimes, full of meaningless and banal statements, but traditionally the law has protected unimpressive speech. It's also upheld the right to offend. What's more, courts and employment tribunals are not in principle supposed to judge what kind of speech is legitimate, but rather to remain neutral on that point. Yet today, the right to offend can no longer be taken for granted. Social media has changed the culture here in the UK and across the world. Employers are having more say in what employees post on social media, or more accurately, a greater ability to take action, disciplinary action, if employees post inappropriate stuff. Before social media, an employer probably wouldn't have cared that much about an employee's private opinions, but what was said in private in the past is today splashed across Twitter, Facebook, TikTok, or Instagram. Opinions posted on social media by employees, whether they are at work or not, cannot always be considered private opinions any longer. The test for whether a dismissal from employment is fair is whether the response of the employer was reasonable in the circumstances, and it stems from a piece of legislation first passed in the 1970s, long before social media existed. Is it appropriate that employers continue to have so much discretion as to what is unacceptable and acceptable employee conduct in a social media age where offence can be taken at almost anything? Perhaps we need new law. But until then, it makes sense to proceed carefully on social media, using it moderately and responsibly. Whether you're an employee or an employer, check your organisation's social media policy if they have one. If they don't, you can buy one from policies2020.com. policies2020.com, which is a set of 20 HR policies I've written, one of which is a social media policy. There's a link to it in the notes below. Either way, maybe it's time to organise some training at work to address the issue of social media use, giving you and your colleagues the opportunity to workshop any concerns. I don't offer training on social media and employment law myself, but the person I always recommend for this sort of training is Darren Newman. I've also included a link to his website in the notes below. I've made other videos that you might find useful, such as this one on when banter at work becomes harassment, and here's another video you might find interesting. If you're interested in these or any others, please do subscribe and click the notification bell. Thank you for watching. Bye bye.